All right.
Good morning. Welcome back to an oral argument session of the 6th District Court of Appeal. My name is Judge Mary Alice Nardella. I'm joined today by Judge Wozniak, and I'm also joined today by designation Judge Chad Alvaro. We're very grateful for his time and efforts with our court and for the Florida Supreme Court allowing him to sit by designation with us today. We have one case left to be heard, and it is State Farm Florida Insurance Company versus Adele Feltes, and it's 23-991. Each side will be allotted 20 minutes of time to make their argument. We typically reserve 5 minutes for rebuttal. Counsel, if you'd like a different increment of time, please let us know. Okay. Counsel for appellant, whenever you're ready to proceed.
Morning, may it please the court. My name is Ryan Jones and I represent State Farm. We have two issues on appeal today. The first relates to coverage under the policy, and the second relates to a jury instruction given at trial. When we look at these two issues, it's understandable how the jury reached the verdict that it did. As to the first issue, I'm sure any homeowner would love if an insurance policy covered the cost to replace some of the major component systems of a home when they wear out.
Counsel, can we begin talking about coverage by walking us through how you view this policy, beginning with the grant, the exclusion, and then the ensuing loss provision, paying special attention to how the ensuing loss provision operates under the policy?
Absolutely, Your Honor. The policy provides coverage for direct physical loss unless it's excluded. One of the exclusions and probably the key exclusion we're dealing with here is wear, tear, corrosion, and deterioration. The ensuing loss provision states that if one of those conditions results in a loss that is not otherwise excluded, then it is covered. And the otherwise excluded is the key portion of that ensuing loss provision. Because the issue that we're dealing with here is the cast iron drain system. And I think everybody will agree that it is a result of wear, tear, deterioration, and corrosion. In fact, that's the exact testimony from plaintiff's own expert, appellee's own expert. The result of that, and again, according to appellee's own expert, is that every time the faucet is open or every time a toilet is flushed, water escapes the system and repeated seepage and leakage occurs.
Why is repeated seepage and leakage a loss? Why is the resulting loss not the structural fill?
If I understand Apelli's argument correctly, the resulting loss is the movement of the structural fill. The leaking of water into the structural fill either displaces it or contaminates it or moves it from its original location. And that's Apelli's theory. But what causes that movement or that contamination or that displacement of soil is repeated seepage and leakage. And that's according to Apelli's own expert's testimony. And it's hard to imagine testimony that would better fit the exclusion. In fact, if I could have scripted the testimony for State Farm, I'm not sure I could have done a better job.
So you believe the resulting loss is the structural fill. It's not the repeated seepage and leakage. You just think that the combination of having two exclusions means that that ensuing loss provision no longer applies. Is that correct?
Not exactly, Your Honor. And I think I now understand your question. I just responded to, and I apologize if I was unclear. The original loss is the wear, tear, deterioration, and corrosion. That creates some type of an opening in the pipe. As a result of that, the repeated seepage and leakage comes out and moves the fill from its original location. So the ensuing loss or the resulting loss is repeated seepage or leakage through the fill, which moves the fill. That is the loss, which is otherwise excluded under the seepage or leakage exclusion. And that's why the policy doesn't provide coverage for it. And we have a couple cases here in Florida that we've cited. The Hoey case is one of them.
Before you get to the case, I mean, just so that I understand you clearly. So there's never really going to be, in your view, a covered ensuing loss resulting from a deteriorated pipe because the primary result of a deteriorated pipe is escaping water and effect on the structural fill.
I'm not sure that I could say never, Your Honor, but in this particular circumstance, no, it would not be covered because it is repeated seepage or leakage that occurs or develops over a period of time. And that's where I was going with the case law because we have a couple cases that deal with leaking over a period of time in Florida, and the courts have applied the seepage or leakage exclusion as a matter of law. And I don't often talk about out-of-state cases, but there are two here that we've cited in our brief that are directly on point factually with what we have in this case. That's the Haas case and the Ellis case. Both of those address a deteriorated drain pipe underneath the home that leaked out into the fill beneath. And both of those cases, coincidentally, involve State Farm, so the language of the policy is similar. Those cases each applied the exclusion as a matter of law. This is something that was taken away from the jury. It was addressed, I believe, on summary judgment in both instances, one of which affirmed by the appellate court, the other was a trial court case. But the logic that they've outlined is exactly what we've outlined in our brief. And all of that goes back to the testimony of Apelli's own expert. It fits exactly into that exclusion. And with the testimony fitting so well into the exclusion, the kind of obvious question is, well, why didn't the jury apply it that way? And that kind of brings us to the second issue, which is because of the way the jury was instructed. When we look at those instructions, the one I want to start by focusing on instructs the jury that the seepage and leakage exclusion does not apply to overflows inside the house. And so far we've been talking about water leaking out of the pipes underneath the house. There was an additional part where Apelli contends their toilet overflowed and that water damaged inside the house. State Farm's expert contended that it was repeated seepage or leakage from a sink nearby, not from the toilet. And that was the factual question. But with that jury instruction that repeated seepage and leakage doesn't apply to overflows inside the house, the jury was almost forced to disregard the testimony of State Farm's expert. And the compounding factor in that was that there was another jury instruction requiring the jury to fine for Apelli unless State Farm proved all of the losses were excluded. And I think the best way to analyze this is to use the example that we outlined in our brief and walk through what the jury would have seen. They would have seen question 2, asking if State Farm proved all of the losses were excluded. They would look back at the jury instruction saying that you were instructed as a matter of law, the seepage and leakage exclusion did not apply to overflows inside the house. They would look inside the house and they would see State Farm's expert testifying that it was repeated seepage and leakage. I'd submit that the most logical result is to look at that and say, well, that the judge has told us as a matter of law, does not apply. So therefore, no, State Farm didn't meet its burden. And
Well, I
that's
can
how
see
it-
that being an issue if there were a general verdict form, but I mean, this verdict form permitted the jury to separate out that which may be excluded and that which may be not, right? I mean, does that fix any? Well, I don't know that there's anything to fix. It's just, it avoids any problem by having a special verdict form, doesn't it?
Not exactly, Your Honor. And the reason is the one question that we asked about, the one question the jury was asked about causation was just that. Did State Farm prove all of the losses were excluded? So let's take the hypothetical where the jury says that the one-time overflow from the toilet was the cause of damage. We believe happily that's. But we also see that there's this long-term seepage and leakage going on under the house, and we think that was probably a long-term issue. If that's the factual scenario the jury looks at. Question number two, did State Farm prove all of the losses were excluded? The answer is no, because of the one-time leak. They then move on to question number three, and this addresses exactly Your Honor's concern, where it says, what is the cost to compensate Appalachia for the losses? It doesn't say the covered losses. It doesn't say the losses you find to be covered. It says the losses. And then it has a question for the interior and the tear out. Under that instruction, it's very easy to see how the jury awarded damages for both components of the law because they weren't given the opportunity to individually separate those two. And when you combine that with the jury instruction that we've talked about, and you combine that with the issues that we're talking about, it's very easy to see how they reached the result they did. But that's not the result it should have been, because that's contrary to what the policy tells us. It's contrary to how the policy has been interpreted under Florida law, and it's contrary to the situations that we've brought up in the out-of-state cases, which again are very, very factually on point, and the logic is the same as we've outlined in our brief. Now, those are the key points that we've brought up. One other issue is with respect to the tear out. Your Honor, I didn't really address that when I was talking about the coverage, but I think the tear out analysis is actually much more straightforward because the tear out is not necessarily triggered by the one-time toilet overflow, and I think the Shotwell case deals with that exactly on point. So that would bring us back full circle to the analysis we talked about earlier, where the water leaks out from underneath the foundation.
Right, but the tear out coverage would be triggered by if the exclusion does not apply, the tear out coverage would apply to, how do I say this? The leaking of the pipe would include tear out coverage if it were not otherwise excluded. You would be able to get to the pipe to replace the pipe and whatever damage was around it if you did not have an exclusion for repeated leakage and seepage.
If it wasn't for the repeated seepage and leakage, I believe the answer would be yes. But I think under either scenario that way, you would have to tear out the foundation to actually get to the damage itself. So you could either call that a tear out or the resultant loss, provided the repeated seepage and leakage did not apply.
One of the arguments that I understand opposing counsel to be making is that there is evidence in the record which would have supported a finding by the jury, possibly, that the damage to the structural fill did not occur as a result of something that was repetitive. It could have occurred as a result of a one-time event. Can you address that and tell me before, counsel comes up here, if there is anything in the record by Mr., I'm going to pronounce his name wrong, I believe, Mr. Jeremico, that would support such a finding?
So the argument that Your Honor is referring to, I believe, is counsel's argument that it was new damage each time the water leaked.
Well, I believe it takes two flavors, right? It's new damage each time, and so it's not repeated. But then I also believe he's making the argument that the first time this happened, it's possible that it caused damage to the structural fill. And so can you address both of those?
I certainly can, Your Honor, and I'll go in reverse order. The new damage each time essentially attempts to characterize the term repeated in a different manner. And I'd submit to you that if something repeats, or excuse me, I'll try not to use the word, if something happens again and again and again and again and again, it is repeated.
Well, let's
That's
get
the-
granular. What is damage to the structural fill? How should we define damage to the structural fill?
That's actually a question probably better for Mr. Nation, but I suspect what he would say is that when the structural fill is compromised, when it can no longer either perform its function or when it is.
So if it's moved once, it's moved twice, it's moved 3 times, it may not matter until the structural fill is no longer fit for purpose. Is that fair?
That, Your Honor, I think goes exactly to the second part of the question you were asking about the very first time the water escaped. We don't have any testimony that I'm aware of in the record that would allow us to make that decision.
What about inferences? Is there any testimony which they could argue you could infer that the structural fill became no longer fit for purpose the first time the pipe leaked?
I think the inference actually has to go the other way. And the reason I say that is because Mr. Jaremko's testimony, if I said his name right, is his testimony was that this is a gradual process that takes place over a long period of time, the degrading of the pipe. And his testimony was that eventually it will wear out and it will begin to, and the leak will grow and grow and grow and grow until there's a point that it has moved the fill and collapsed the pipe once the fill has moved out. He never indicated that the very first time of a release of water, that it was a sudden rush or such a volume of water that all of the fill was moved away, which then allowed the pipe system to fall and cause the backup. We don't have that testimony. In fact, we have the opposite, where he explains very clearly that one side of the plumbing system was much further along the deterioration process than the other. And I believe his testimony was that most of the water goes down the pipe, but a small percentage comes out. That suggests that it takes quite some time for enough of the fill material to be moved or transported or whatever the case may be to constitute damage, as Your Honor was suggesting, that we need to do something to displace it from point A to point B. And so I think that the only inference we have is just the opposite. It could not have been a one-time event. And I know that counsel is also relying on an out-of-state case, the Wheeler case. And there is something in the Wheeler case that speaks exactly to that. The court distinguished between an abrupt crack of, it was a gas pipe in that case, where gasoline flowed out, as opposed to a small corroding hole that began to trickle and gradually over time expanded. And I think that is exactly what we've just been discussing about how this system broke down over time.
Counsel, whose burden would it be to show, and I'm thinking particularly about the Hicks case, which was discussed below. If we were to adopt that reasoning, which I don't believe our court has ever done, but if we were to adopt that reasoning, whose burden would it be to show that that the leak did not displace the structural fill enough to compromise its use the first time?
It would be Appleby's burden, and I'll explain. But before I do, Your Honor, I have to submit that the Hicks decision should not apply to this case because the policy language is different.
We understand.
Okay. Here, what we would be dealing with when it comes to the burden of proof, the initial burden is on the homeowner to show damage during the policy period. The secondary burden, once that's met, and if that's met, is on the insurance company to show an excluded loss. And here again, we're dealing with wear, tear, deterioration, and corrosion, and that's met by everybody's testimony. And then if there's an exception to the exclusion, such as an ensuing loss, the burden shifts again back to the insured to prove that exception to the exclusion. And I don't think any of the cases in the briefing dealt with that, Your Honor, because I don't think either of the parties brought that up. But if the court's interested, the one that originally said that was the Gajwani case, and that's Gajawani from the 3rd DCA. So it would have been the burden of Appleby to show that damage. And again, we just don't have anything from Appleby other than the testimony of their experts saying this is repeated seepage and leakage that has occurred for a period of months, or I believe he even went on to say years. And that again fits exactly into the policy exclusion. So unless the court has any further questions, I'll reserve the remainder of my time for rebuttal.
Counsel, could you address the preservation issue with the second challenged instruction? Because it seemed like the argument made below with regards to that instruction was a bit different than what's being raised on appeal.
It is slightly different, Your Honor. So the preservation issue, the record site, I believe, is transcript page 709 is where the discussion begins, and it went for the next 4 or 5 pages. And what trial counsel argued was that we can't have multiple losses. If you have that phrase loss, or that term losses plural in the jury instruction, you have a problem because you don't know which loss you're dealing with. And the examples he gave were an overflow from the kitchen sink around Thanksgiving of 2018, a toilet overflow, and then another toilet overflow later in time. But the concern and the logic is the same. His concern is when we go to prove which one is being excluded or which one is covered, we need to know which one we're talking about. And that's the exact same argument we're making here.
But he was more concerned about the policy period, correct?
He was more concerned about the policy period, correct, because there were actually 3 different policy periods that were addressed throughout the course of the trial. But the issue though is still the same, I submit, because we're dealing with multiple losses and we have to figure out, we have to find a way to separate which ones are covered and which ones are not. And if we group them all together and we don't have some kind of an instruction that breaks it out or a verdict form that specifically asks for the amount of money to compensate for the losses that are covered is the key language. Then everything is grouped together and you have the result that you can hear where the jury wasn't given the opportunity to say that one loss is covered, for example, and one's not. And so if the court has no further questions, then I will complete anything else on rebuttal. Thank you.
Good morning, Mark Nation, on behalf of Ms. Phelps. I'll start with the first question I believe you had, and that is, how does this policy operate? It's kind of odd because it starts with losses not insured, but that's where we get our coverage. And it says, and this word wasn't mentioned, that in the argument just heard, cause. The focus is cause. The same problem happened in Hicks. The insurance company never mentioned the word cause. I will be doing so. We will not pay for any loss caused by seepage or leakage of water, which occurs or develops over a period of time. So cause. What they wanted to read is, if there was seepage or leakage over a period of time, it's excluded. But the burden of proof is on them to prove their exclusion, and they haven't even tried to address cause. And so we'll look at Hicks. I get the language is good. Hicks says we will not pay for any loss caused by constant repeated leakage or seepage over a period of 14 days. So let's take that 14 days out. Let's not do that yet. Then Hicks said that means losses which occur under 14 days are covered. And the burden of proof is on the defendant who's asserting the exclusion to prove that any losses which occurs over 13 days are excluded or occur in what they are, and those are excluded. So anything under 14 days covered, anything over excluded. Let's look at our case and we'll sub in the words. We will not pay for any loss caused by seepage or leakage over a period of time. And so that's their language, over a period of time. And it uses the same word, over. Well, anything under the expiration of that period of time, whatever it is, we don't know that is covered.
Counsel, what do you say to the cases that have criticized Hicks outside of this state that say that it focuses on what you just described, cause, instead of the nature of the peril?
But you have to look at cause. Cause triggers everything in the policy. If you look at everyone.
Well, how does that square with the ensuing loss provision not saying cause? I'm sure you're going to get there. I probably jumped the gun.
No, it's fine, because it says we will pay for any resulting loss unless that loss is excluded. So they do say we're going to pay for a resulting loss. Obviously, we're not there yet. They got to prove their exclusion first. And they can't prove their exclusion. They didn't try to. So any loss in less than a period of time is covered. Any loss over a period of time is excluded, but they have to prove what that loss is.
Okay, can I stop you there? And I appreciate the full picture. I'm probably going to need it again. But if we just focus on the over a period of time, I'm going to ask you the same question I asked opposing counsel. Is there any evidence for which an inference could be made this was anything other than damage caused over a period of time?
100%. And we're going to take the pipes out because we agree that, I think we all agree, the pipes fail due to wear, tear, deterioration, and corrosion. Think of it as a tile. Over time, it just wears out and then pops. Same thing here. Over time, it deteriorates. There is a point when it fails. Then the water, the sewage escapes. Once that escapes, that first time, that is damage. That is displacement.
Why?
Because it as a matter of physics, must displace, and that's the only evidence.
So it displaces, right?
Yeah.
But the displacement only matters once it affects the pitch, right?
No, because once that is, let's say, this is a vanity, and it's now wet with category 3 water. It's a component of the home. The structural fill is a component of the home.
Right.
My client will now have to report when they sell their house, on a seller's disclosure. I've had water damage to the home. Same thing for the fill. There's water damage to the fill. It is a component of the home, which is now has category 3 water in it. That by definition, the only evidence in the case is the IICRC says that is primary damage. The wetting of a material, whether reversible or not, regardless of color or content.
Okay, so you disagree with the damage that I described, damage being it's no longer fit for purpose. Your definition with damage would be, and the second it gets wet, it's damaged.
Correct.
Because now you have to report it when you sell your home.
That is one of the reasons, but IICRC tells us that is primary damage. The wetting.
What's
of-
IRCC? I'm sorry.
It's, Mr. Jarenko testified about that. And it is a ANSI standard in a code he has to follow in order to remediate.
So an industry
damage.
standard describes the wetting of structural fill as damage.
And it specifically says that primary damage is defined as, well, it doesn't say structural fill, the wetting of any material. And then it goes on to say any material that's porous has to be discarded immediately. And I believe we also put in building codes that said water escaping as soon as it escapes is violation of the building code and would have to be repaired.
So how does that inform our analysis, though? I mean, there's a bunch of different considerations that go into an industry code versus the interpretation of a policy. And
Sure. They didn't define damage in this policy. Nowhere in the policy do they define damage. The closest case we have is a case of mass ponds. Mass ponds, there were 2 issues. It was summary judgment. The first issue in mass ponds was the trial court defined direct physical loss. So that's the trigger for coverage. Here it's accidental, but I don't think we're arguing about the word accidental. And they define direct physical loss as the failure of the drain line to perform its intended function. That was affirmed. Then there was the second issue. The trial court said, and because that's the definition of direct physical loss, insurance company, you owe money. That part was removed. So the part, that went through, that was a jury question. That's what happened here. We had the failure of the pipe to perform its intended function. No question about it. As soon as the second it came out of the pipe, it failed to perform its intended function. And now, once this is wet, the cost is set. We've got to open it and repair it.
So no matter how minuscule, no matter how minor, damage occurs to the structural fill, which requires enormous expense to fix. Second, 1 drop of water touches structural fill. We'd have to accept that argument.
No, in that case, if it's minor, and here it wasn't minor, we could see the whole pipe had opened. But the evidence in the way we presented it was that fails at a very particular moment in time. That failed. They could have their plumber say, no, it didn't. In fact, their plumber said it didn't fail. And so that becomes a jury question. If it had been minor, then that tear out would be limited to that small area. That gets us to question 3 on the verdict form.
let me make sure that I'm on the same page as you, Mr. Nation. Are you saying that damage is covered under the general insuring provision or under the resulting loss provision?
Because it was due to wear and tear, it would be resulting.
Okay,
It would have to be resulting. Because that's the wear, tear, deterioration, and corrosion occurs. Clearly that occurs over time, but that doesn't get them their exclusion. Their exclusion is they got to prove that the damage to the fill occurred over a period of time, which is not defined. And there's only, I think, 1 Florida case on that. There was a supply line leak that happened over 3 months. Thousands of gallons of water went out and damaged things. Here, once the water escapes, and if it's a minuscule part, that's the only part that they get to open, that they have to pay for. But here, the evidence is it was not a minuscule part. There was a channel through the entire system. Our position was it's very slow, and then all at once. And that occurred. Then they could defend, let's say, and it gets to question 2. I'm going to bounce around a little bit now.
Wait, can I bounce around,
Please,
counsel?
please.
If I reject your definition of damage and I say it has to be displacement enough to affect the drainage system underneath the house, if that's how I define damage, then what is the evidence for which I can say the jury could have inferred that that definition of damage was met?
As soon as the water went out, we probably used this example in trial. Think of a hose pointed at the ground.
You did use it.
Okay, and so it displaces. That affects the structural integrity of that pipe. Without a doubt, and that should be the only evidence about that issue in this trial, is that once this is displaced, it affects the structural integrity. I don't know when it drops or how long that takes to drop, or if it drops from that one thing.
I mean, you talk about at trial, I think it drops in the sand, right? And how each drop is different and how this makes it new.
Yes.
But it makes me think that a drop in the sand the first time isn't enough to compromise the foundation.
Well, and we
Well,
didn't
and
have-
I mean, maybe is it the fact that the drop in any sand might not matter, but this is a drop in the sand that is structural fill, and therefore by definition, it's causing some sort of compensable issue with the foundation, right?
100%, because it
Okay.
is compacted. As soon as it goes, and we don't have.
Your argument is you don't have to wait for the adverse effects of the damage to the structural component in order for there to be damage as a matter of policy.
You can address, according to this policy, you can address it before it gets worse. And remember, they took 2 months to even get out after the loss. There's no evidence that this failed anything other than at a moment in time. Of course, it was slow, but the only evidence is that it failed like at the top. And then it is now beginning to displace the film. That policy language is triggered at that point. We don't have to sit back again and wait for that to get worse before it's covered. And then they say, well, now it's excluded. We can address it before it's back picture. And the cost is the same, by the way. Whether we address it at the moment it failed or long after, the cost is the same. And we I'm sure, limited our scope and price to that time. I think it was March of 2019 when this backup occurred. And then we have videotape showing in the policy period, the condition of the pipes. But all these were arguments that we made at trial. I mean, they were allowed to make these arguments at trial. Let me see if there's anything else. Again, I think Hicks is the right way. Was my case, of course, I'm going to take that. So, but it makes logical sense that if they say we don't pay for loss over 14 days here, over a period of time, that loss under that period of time would be covered, and the burden's on them to prove their exclusion. They have every ability.
Pretty impossible burden, right?
They wrote the policy.
I understand, but it's you brought a new interpretation of the policy, whether it is or isn't correct. It creates a pretty impossible standard for them to meet. They have to prove the first 14 days and
But cause, they get back to cause, because the only way that it covers every loss unless it is specifically excluded. They could have said we pay for no losses caused by wear and tear. Electrically, but they chose not to. And they chose to specifically say from a plumbing system, they're going to cover, I'm sorry, this policy doesn't sum it up. We won't cover wear and tear, but we will cover any resulting loss. There's clearly resulting loss for the structural fill. In loss, the only definition we have in Florida is the failure of the pipe performance intended function is direct physical loss. I get that it was hard, but they could have written their way around it. They can still do that. They've left this policy this way for years and years. But to address the other issues, I pulled the verdict form as I went through their arguments. They didn't object to question 1. They did object to the issue that's raised in question 2. What we did in question 2 is quoted their burden of proof, word for word. The State Farm proved by the greater weight of the evidence that all the losses claimed by Plymouth were caused by things excluded by the policy. The only objection they had to that jury instruction The only, the jury instruction on burden of proof was that counsel said on page 712. He thought it should be the word loss instead of losses. Their brief seems to say, in addressing burden of proof, and they unpack that jury instruction much more than what was done at trial. You know, and he goes, the one and only loss that I'm willing to admit was the March 12, 2019. Our position was she reported all of this stuff to them, all of it. And he says there is a loss that was reported. What they were getting at on page 712 was some sort of post-loss conditions about reporting the earlier Thanksgiving loss. They've not appealed anything about post-loss conditions. The only thing, well, they reconstructed.
They didn't even
this
go to the
argument.
jury on post-loss conditions. I don't
No,
think.
they
Correct.
didn't. Yeah,
So-
they didn't appeal it.
Right, we
It's-
understand.
And then they didn't offer an alternative either. If you look at their verdict form, it's forms, 51 questions on their verdict form. They don't even, and they never argued that to the judge. Counsel said after that loss, it should be loss, not losses. That was the only issue. They cannot get past special in West Boats and show that that was somehow harmful. I don't think they even tried to. But then offering, they didn't say, and here's our alternative. They said, we filed some verdict forms and jury instructions in the record, and that's it. That's the only mention of their own verdict form, their own jury instructions at all. And then question 3 on the verdict form, they agreed to. And here today, counsel has said, you know, it should have said, what were the covered ones? Well, they stipulated question 3 on the verdict form as written. So that's been abandoned. If we look at the, the discussion on the verdict form is page 1139 to 1141. Then we look at the jury instructions as read, even if they had objected to question 2 on that verdict form, it is an accurate statement of the law. If they have 2 or 3 affirmative defenses, exclusions, the burden of proof is on them to prove every element of each one. If they don't do that, then we get to damages. And if they do, if they prove all my client's losses are excluded, at that point, the verdict is in favor of the defense. If they don't, we get to damages. Now they get a second bite at the apple on damages. And they can say, well, fine, water damage to the vanity, that's covered, but not pipes, and here's why. So they can fight us on our burden of proving the damages. But none of this was argued below. We had a problem with the word loss. Should have been losses, or losses should have been lost, and that's it. As to the argument on the instruction on constant repeated leakage receivage does not apply to the overflow house. I don't know if I need to address it. He said, I'm not going to argue that. That's not our position. We all agree that that is covered. Time and again, we don't disagree that that is covered. And I said, well, then what's the harm of this instruction? He says, I don't understand what it's saying. It's crystal clear what it was saying. That overflow in the house is an exclusion. They've stipulated that.
Counsel, I want to make sure before you leave that I understand. Your argument as to damage. Damage is not defined in the policy. The industry says that as soon as the structural fill becomes wet, it is damaged. So I guess you're arguing that we should accept an industry definition. Is that
It's
accurate?
the only evidence in this case, but yes,
Okay.
I do.
The owners are going to have to report wet structural fill, that structural fill became wet when they sell their house. And you're arguing that displacement occurred the first time.
I do.
Okay.
I think that's.
And that would be supported by an inference from the idea that the leak is the bad word, the hole
Oh, I don't
in the
use the word
structural,
leak.
very smart. That the break in the structural pipe was large. What
Well-
is the evidence that you would point me to for your last argument that displacement occurred the first time?
I think if you look at Mr. Jeremko's testimony, and I know it's long, but as soon as it broke, it comes out and fill comes in the pipe, as soon as it does happen. As soon as that happens, that has to be addressed through tear out, whether it's the additional coverage tear out or just accessing the damage.
I appreciate that, but I guess my question is different. Where can I find Mr. Dremko telling me that the structural fill is displaced significantly enough that it no longer is fit for purpose as a foundation the first time?
I don't have that off the top of my head. So, and I'm sure I addressed it with him, but I can't tell you exactly.
We'll go back and read it.
And I think that's it, but I don't want to lose sight of the bathroom, the water damage in the bathroom. The testimony, the only testimony in the case from our side, and I don't think was contradicted, was that the condition of the pipes is what obviously caused that water to come out of the toilet. But that's one column of water. It's coming from the entire system. It's not simply coming over the lip. This coverage would provide no coverage whatsoever if that was how these losses occurred. In Shotwell, they specifically said there is no evidence that any water escaped the corroded pipe under the kitchen. Indicating, I think, if it had such evidence, that would open up for tear up. Our evidence was that the overflow from the toilet was caused by the entire system. So it's not just over the top of the lip, it is the whole thing that caused it.
All right, thank you, Counselor. You're out of
Thank
time.
you.
May it please the court. Your Honor, I'll start with addressing the question the court had about the damage occurring the very first time. I don't recall any testimony from Mr. Jeremko that specifically said there was damage or displacement of the structural fill the very first time it moved. In fact, I was looking while Mr. Nation was speaking, found something to the contrary. On transcript page 282, Mr. Jeremko explains how the leak starts and over time it will eventually get to a point where the system won't drain anymore. What that suggests is that the severity gets worse and worse and worse over time. And I think that's consistent with a common sense approach to a single drop for the very first wetting. Because if wet fill truly is damaged, then every single time it rains, we have damaged fill.
So that was going to be my question. I mean, if you assume Mr. Nation's position that there was damage upon the first drop, is there any fallacy to that being covered, but if it continues, it not being covered because it then comes within the exclusion for seepage and leakage?
Well, and that's a very good point, Your Honor.
I mean, would that be a bad result, having coverage under one circumstance and not under the other?
If
Not
I
in-
understand your question, the very first drop could be covered, but as it continues, it is no longer covered. Because
Yeah.
It is continuous.
Because it then becomes seepage or leakage over a period of time.
I think yes is the answer with a caveat. And I think all of this makes sense when you look at the big picture of a policy. The policy is not a home warranty policy, and it doesn't guarantee that a plumbing system will last forever. They will wear out, they will degrade over time, and they will need to be replaced. Mr. Jeremko testified that that's a natural progression. There's no way to avoid it. What we have here is, if we look at either concept, the first drop couldn't possibly be considered damage because it rains, there's sprinkler systems,
How does a rain or sprinkler system damage structural fill?
I'd submit that it doesn't, Your Honor, and that's exactly the point. If a single drop or any wetting of structural fill, which is what I understood Mr. Nation to argue, is considered damage, then rain damage, then sprinkler systems damage. And if you're asking about the mechanics of it,
Well, how does it get to it?
rain hits the ground and then it soaks into the ground and leaches through both forward and backward and up and down in all different directions. It's called capillary action. There wasn't much, but there was a little bit of testimony about how water moves through soil in the record. But the point of it is that the water or the soil will get wet through other sources, natural sources that don't damage it. So the concept of a single drop wetting it constituting damage simply doesn't make sense. It can't be considered damage that would hurt it. The testimony that we have, and I think the easiest way to address this issue is to focus on the testimony that we do have. Mr. Jaremko, and again, this is on transcript 283. He explained that every single time the faucet's open, every single time a toilet is flushed, this water escapes from the pipe. And again and again and again, it repeats. He actually used the phrase repeated seepage and leakage. That's what he described as occurring. And on that 283 that I was talking about, he goes through a 1, 2, 3 year period where this happens every single time the faucet's open or the toilet's flushed.
Does Mr. Drumco, or is it your expert that begins, assumes that the start date of the leak was the kitchen overflow?
I don't think either of, it was Mr. Jaremko, but I don't think he assumed that was the start date of the leak. I think the testimony was, he said when the kitchen sink overflowed was when the system finally gave up and failed. And that was during an exchange between Mr. Nation and Mr. Jaremko, where a system going through the stages of degradation will drain slower and slower and slower. There will be backups, but no overflows, backups, but no overflows, and eventually it will overflow, and that will continue over and over and over again. But unfortunately, that wasn't really tied to whether or not it's leaking underground. The testimony that we have about leaking underground is what I was just referring to when it happened over that 3 year period, every time that the faucet was opened or the toilet was flushed. And if we put that in the context of what was reported to State Farm, I think this is the key. Because the October 2018 was the earliest that he was testifying that every single time the system was used, it was leaking. That means from October of 18 all the way through to when the claim was reported in 2019, there was leaking every single time that the system was used, repeated seepage and leakage. That's a period of at minimum 4 months. And when we look at something under Florida law that occurs over a period of 4 months, we have at least 2 cases that we've cited in our brief that say that is over a period of time as a matter of law. That's the Hoey case, and I'm probably going to mispronounce this terribly, the Desha Zer case. And I see with that, I see that my time is up. So if the court doesn't have any other questions, then we'll rest on our briefs.
Not that we have any. Okay. Well, counsel, I want to thank you guys for your arguments and your briefs. It was well argued.
Thank
We
you very much.
appreciate that. We are adjourned.